Can we go back just a little? I mean, you've been trying to explain the reason why, first of all, the appointment of the acting chair is invalid. Yes. But some people will say that the Constitution rarely recognizes or even makes provision for any position that is acting. What usually the Constitution will prescribe is the position or how to appoint a substantive chair in almost everything. I mean, even if you're talking about service chiefs or police IG or what have you, the Constitution doesn't spell out acting anywhere, but we recognize acting, I mean, in normal parlance and in society. So I'll ask, first of all, in INEC, when Professor Jega was leaving, he did hand over to somebody who was acting. Would there have been a problem if, you know, he was acting in that capacity? Would you say that the Constitution recognizes that? Now,
let me tell you something. It's like, you know, Jega will not say that when he leaves, maybe during his term, you cannot say that Jega was there 24 hours in INEC working. There are times that he will travel out of what? INEC. The question you ask yourself, to whom does he hand over to? Somebody was acting. It's an administrative matter.
No, but that's different.
The implication, therefore, is that to allow what we are now having now is to impeach on the, in fact, on the independence of INEC.
But isn't that different? If you say he steps
it's not different. It's
momentarily.
not different.
No, it's different because he's still in office. At the time he steps out, he says, look, just standing. That's different from handing over because my term is statutorily over.
Yeah. Now, I agree that to some extent, we're only looking at what, you know, happens if the substantive chairman is not there, so to say. I only gave an example. Okay, we agree. You may say that that example does not fit. Now, we want to ask further. If the provision of the Constitution, because there are two contradictions here. The contradiction by the president to appoint an acting chairman and the contradiction of the former substantive INEC chair to have handed over to another as acting chairman. Now, between these two contradictions, which one, for all intents and purposes, appears to be more rational or more inclined to the in furtherance of this constitutional provision?
If you say it's a contradiction.
I mean, it's a question. I mean, it's a question I want to answer it.
But, okay, answer.
I want to answer it. Now, because, no, why I say so is that, look, I have said it clearly that the provision of the Constitution did not make provision for acting chairman in respect of INEC. And I'm more emphatic on that because of the way that provision was couched. And I'm saying this because the proviso to section 160 was never part of the 1999 Constitution until 2011, when it was signed into law. And it's like those are some of the things that some of our colleagues are missing. It was never part of it. What we had before 2011 was the natural state where it is the president. Consequently, he will not exercise that power just like he does in the appointment of other service chiefs and so on and so forth.
What's the proviso? Sorry, would you kind of read it out?
With due respect, I'll read out the proviso to section 160, the alteration. Now, the alteration provision, the Constitution of the Federal Republic of Nigeria, First Alteration Act, 2010. It reads thus, paragraph 16 of the alteration said, section 160 of the Principal Act is altered. This Principal Act, that is this 160. Perhaps I'll read out what 160 says first. Subject to subsection 2 of this section, any of the bodies may, with the approval of the president by rules or otherwise, regulate his own procedure or confer powers and impose duties on any officer or authority for the purpose of discharging his functions. Now that goes to the alteration, the section, paragraph 16 of the alteration provision, to the effect that, look, section 160 of the Principal Act is altered. In subsection 1, line 4, by inserting immediately after the word, subsection 1 is what I've just read, section 161. Immediately after that subsection 1, he said, look, you insert the following. He said, by inserting immediately after the word functions, the words, provided that provided that in the case of the Independent National Electoral Commission, its powers to make its own rules or otherwise regulate its own procedure shall not be subject to the approval or control of the president.
To make its own rules.
Yeah.
It's talking about
He used the word functions. He said
about rules and procedure.
Yeah.
Because here, I'm reading in 160, subject to subsection 2 of this section, any of the bodies may, with the approval of the president, by rules or otherwise, regulate its own procedure or confer powers and impose duties or any other officer or authority for the purpose of discharging its function.
Yeah.
Now, if you look at the proviso that you're reading, you're saying that it grants an exception to INEC.
Exactly.
In the case, would you kindly read that again?
The provision. Section 160 of the Principal Act is altered. In subsection 1, line 4, by inserting immediately after the word functions, the words, provided, after the word functions, you now go further and say, provided, provided that in the case of the Independent National Electoral Commission, its powers to make its own rules or otherwise regulate its own procedure shall be subject to the approval or control of the, shall not be subject to the approval or control of the president.
That's where, you know, some people might say it gets controversial because all we're talking about is rules and procedures. But first of all,
no, but you will not rule out the issue of function because it takes something about functions first. That's why I say immediately after function, you now come up with the proviso. So that concept of function is still part of it because you are looking at what will make you function. And not what will make you not to function.
The thing is this: what I'm trying to ask you is about, you know, the concept of acting, because you say that that concept is illegal.
It's alien.
It's alien to the Constitution.
Yes.
And now you were saying that you're also bringing the argument to the independence of INEC.
Yes.
And I was asking, you haven't quite answered that, you know, as to whether or not, if the INEC chairman, when Professor Jaga was leaving and had handed over to somebody and that person was in acting capacity, would the Constitution have recognized that person?
Now let me tell you, my answer to that question is that it is we that have labeled the action of the person to whom Jega handed over as being in an acting capacity. It's an issue of nomenclature.
What does that mean?
Now, I'm saying that because when Jega handed over, so to speak, somebody needed to continue to help in the functioning of INEC to carry out its constitutional responsibilities. And that was why he handed over to that other person, as it were. And we now, quote and unquote, labeled it as being what? Acting.
What is that person? If we did not label the person acting, is the person substantive? Because we do know that there is a procedure for appointing a substantive person.
That was why I was being very careful with my word. I said, look, the provision of this constitution did not give room for an acting chairman of INEC. That was what I said. And I said, okay, we are faced with the appointment made by the president to say somebody is now there as an acting chair. Vis-a-vis that appointment, or vis-a-vis the one that Jega himself did, which of course we all regarded as being acting as well. I said those are two contradictions.
No, the reason why I'm taking you up on this is because you are talking about the very word acting.
Yes.
You have not talked about, you know, who exactly makes that acting appointment. It was him. My point is that, you know, if you say that one person, or if you say that the word acting is alien to the Constitution and thereby illegal.
For the purposes of INEC.
Just a moment. And you also say that it is illegal. Unconstitutional.
Yes.
It also means that regardless of whoever it is, whether it was Jaga who handed over to the person or it was the president who appoints the person is alien to the Constitution and so cannot act.
No, it's not alien. Let me tell you, if Jaga since the appointment was done by Jaga, it's not alien. Because one, the Constitution gives them room to regulate their own rules and procedures.
When did the
and how they are going to function.
How did the Constitution differentiate between who hands over, you know, or who appoints? Did the Constitution do such a thing? No.
You don't get what I'm saying. Of course, the Constitution cannot cover the field, just like that. One thing you can be sure of that the Constitution will at least give you a leeway. And that leeway is that there is a constitutional backing, or what we call a legal backing, in the fact that Jega handed over to somebody who is to continue in that role, pending when there is a substantive appointment. Backing? Constitutional backing. That's what I'm telling you, that by that proviso, the question you ask you, what is the circumstance under why that proviso will operate? Was that proviso put there for, just to make up the provision of Section 160? It's a fundamental question. So you ask yourself, where is the circumstance under which that proviso will operate?
But the thing
is, this is that circumstance where, because to avoid a vacuum, there is need for that provision to be invoked. And that's why I said it is the only provision that came close to even being more constitutional than the one that was done by the president, that in fact clearly shows that there is an external interference of the independent. That was why, because of the need to avoid that.
Mr.
That is why, very well.
Why didn't Jega, for instance, the former chairman, hand over to the secretary of the commission?
Why didn't he hand over, since it's an administrative thing? Yeah. Why did he not hand over to the secretary of the commission, pending the appointment of the substantive head? Now, the question you ask yourself, to whom did he hand over? For you to be, for the person that the provision ought to, the person that should be handed over to must be a member of the commission. The secretary is not. The secretary is not. And because the provision is clear that for it, the chairman can only be from among the members of the commission.
But the thing is,
those 13.
Since we are months away from the November elections,
very well,
all of this can be corrected before the elections.
Why not? He still falls within the purview of the powers vested in the president to do so. Particularly with the vice president, who of course I know is an authority when it comes to law, as it were. So I guess perhaps because of the absence of a substantive AG, that could explain why this kind of appointment was made, without reference to it. And that was why I was making reference to the fact that for anybody pointing to the fact that there was enacting this under Shuebi, it was under the former law, not under the current position of the Constitution.
All right, Mr. Mathias Emeribe is a legal practitioner. Thank you for talking to us today.
You're welcome.
We'll be back after the break. Don't go away.